Good to go, Judge?
Yes.
Okay. Could you state your name, please?
Danielle Trigger.
All right. Detective Trigger, how are you employed?
I'm employed by the City of Troy Police Department.
Okay. Are you a detective?
I am.
Okay. Could you tell the judge briefly, well, are you on a special assignment right now?
I am.
Okay. Back in January of this year, were you not on that special assignment?
That's correct.
Okay. What were your roles and responsibilities on January of 25?
I was assigned to the Detective Bureau with
Okay.
the City of Troy.
All right. And as part of your job with the Detective Bureau, did you become involved in the investigation into the death of Thomas Cooper?
I did.
Okay. How did that happen?
I was the on-call investigator at the time. We received, or I guess overheard, a dispatched run to a particular location in reference to an explosion that had occurred and responded to that location.
Okay. And was that location in the city of Troy in Oakland County?
Yes, 165 Kurt, Suite 500, I believe.
Okay. And Detective, when you arrived on the scene, were you by yourself in a car or were you with other officers?
There were multiple investigators from our Detective Bureau that arrived together. We showed up shortly after the initial road officers had responded to the scene, and EMS as well.
Can you describe to the court sort of what was the scene when you walked into the Oxford Center?
Chaotic would be the first word I would use to describe it, I guess. When we arrived, there were some females outside of the location in scrubs, very distraught. There was an ambulance there. Once we entered the building, there were some fire department members that were inside of an area that contained 3 hyperbaric chambers. I was unaware of what they were at the time. The middle of those chambers was visibly very burnt. There was what appeared to be a gurney partially pulled out of that chamber with the corpse of a small child. I mean, unrecognizable, whether it would be a male, female age, burnt severely. The ceiling tiles had been blown out as a result of what we figured was the explosion.
When you say they were blown out, what made you come to that conclusion?
They were completely missing from the ceiling. Smoke, there were firefighters still actively kind of trying to mitigate the effects of the fire that had occurred. And that was, we started in that primary area, subsequently moved to a next door suite where some of the employees of the facility had gathered and began doing interviews with those individuals.
Okay. Did you have an opportunity to speak with Miss Aleta Moffitt?
I did not speak with her directly, no.
Did you see her on the scene that day?
I did.
Okay. And I assume there'll be a stipulation that Miss Moffitt's in accordance with that?
I'll stipulate to inquiry notification.
Okay. Thank you. Thank you. You said you didn't have any you didn't have a conversation with her.
Correct.
Okay. And was the defendant Tammy Peterson there?
She did arrive a short time after we had arrived on scene.
Okay. To your knowledge, were any of the other defendants, Mr. Mosteller or Mr. Marken, were they at the scene when you arrived?
When I arrived, no. Mr. Mosteller did make the scene shortly after our arrival. I did not see Mr. Marken on the location.
And did you have any conversations on that day with Mr. Mosteller?
I did not have any direct conversations with any of the other defendants on that day.
Okay. Did you happen to overhear the defendant Tammy Peterson speaking with someone about the Oxford Center?
I did.
Okay. What did you hear her saying?
It was something to the effect of the manufacturer.
Obviously, Judge, I just rise to object.
No, go ahead.
Just that obviously you're using Crawford and only applying what one witness says or one defendant to that defendant, not mine or any others.
Yes.
Yeah.
Go ahead.
Thank you. Go ahead, Detective.
It was something to the effect of the manufacturer had to get out there to figure out what had gone wrong because they do everything by the book.
Detective, while you were on the scene, was Detective Flood with you that day?
Sergeant Flood was there, yes.
Sergeant, yes, thank you. And eventually, did the two of you begin sort of looking around and taking an assessment of what was present on the scene?
We did.
Okay. Did you personally or did you observe Sergeant Flood recover any materials that day?
It was not Sergeant Flood that
Okay.
recovered the materials. It was Detective Nick Barrett.
Thank you. Do you recall what Detective Barrett recovered? let me ask that a better question. Do you know what he recovered on the scene, or did you have an opportunity to review materials that were recovered later?
Both of those things are true.
Okay.
I was aware that Detective Barrett was taking on the task of retrieving medical records or records that were available as it relates to treatments for the victim, maintenance logs, things of that nature specific to the unit that was involved in the incident, and a manual for the unit that had been involved in the incident.
Let me take two of those things separately. You said maintenance logs for different chambers.
It was, I guess, check logs. I referred to them as maintenance logs at the time. It was sort of a checklist of things that were gone through for the chambers that were in that room.
Okay.
So a checklist.
How many logs do you recall there being?
I could not tell you off the top of my head.
Okay. Were the logs associated with particular hyperbaric chambers?
So it was a checklist that was supposed to be, if I can recall correctly here, a daily and a weekly to check all 3 chambers that were within the vicinity of that room.
Okay. Were the chamber logs, did they reference a specific serial number in them?
No serial numbers. I believe it was just chamber 1, chamber 2, and chamber 3
Okay.
were the headings across the top.
All right. And you also indicated, did you have an opportunity to see recovered a user manual that belonged to the hyperbaric chambers?
Yes.
Okay. And is that People's Exhibit 5 that's already been admitted?
Yes.
Okay. Did you have an opportunity to review that at some point?
I did.
Okay. Tell the judge when that was and what did you notice?
I was approached by Detective Barrett, who had had an opportunity to look through it on the scene, and he referenced a portion of it specific to a wrist strap, grounding, things of that nature. When we returned to the police department, I had an opportunity to sit down with Detective Barrett and take a look at that portion of the manual, observe the picture of the item that had been described, then re-reviewed the video that we had obtained of the incident occurring that morning to assess whether or not it appeared that item had been implemented inside of the chamber.
All right. And did it appear that the
No.
item had? No? Okay. Thank you. Detective Trigger, was it that day? Strike that. Let me ask that a better way. On that day, did you take note, or do you know if someone photographed the counter on this particular chamber?
So I know for certain photographs were taken by our evidence technician at Troy, which would have included a photograph of the counter on the side of that chamber.
All right.
There were also photographs taken by representatives of the fire department.
All right. And
Object to the relevance of the counter, Your Honor.
We've had 3 experts today in this exam that say the counter was not relevant to the cause
And-
of the death.
still part of her investigation as a whole, Judge, so I think it's relevant.
I'm going to allow the question and overrule the objection.
Thank you. And Detective Trigger, I'm specifically referring to photographs that have already been admitted in People's Proposed 1, which is photographs taken that day. Was a photograph of the counter taken that day?
Yes.
All right, do you recall what the counter was at on January 31st, 2025?
I believe it was 19,894.
Okay, thank you. Detective Trigger, did you have an opportunity to go back to the Oxford Center? I mean, multiple times.
Yes, I did.
Okay. Did you go back on February 1st?
I did.
Okay. And why did you go back there that day?
After attending the autopsy for Thomas, returned to the police department, continued to review some of the records that we had recovered, made contact with the other patient who had been present at the time that this incident occurred, spoke with her regarding the utilization of a grounding wrist strap. She indicated
Objection.
that...
Yeah,
Yep, go ahead.
Hearsay.
that's okay. Without saying what the other patient
Yep,
said.
okay.
Yeah.
It's continued to look into whether or not grounding wrist straps have potentially been utilized at the facility, determined that that did not appear to be a common practice. Additionally, reviewed photographs of the chambers themselves, saw that one of the wires on the back of that chamber, when compared to diagrams of the chambers, wire that appeared to be related to grounding had some electrical tape on it and looked vastly different from the other 2 chambers that were inside of the facility.
Your Honor, I'm going to object to any reference to the, I'm sorry, you said electrical tape?
Correct.
Right? Because as far as I can tell, no one knows when this tape was placed on the chamber. No one knows who placed it on the chamber. And so it's entirely irrelevant to all 4 defendants because no one knows anything about this if any of the 4 defendants had anything to do with it.
I'd also add, Judge, to that objection, the relevance portion of it, you've heard it nauseum. And I don't know how to get up past this hurdle. You've heard it nauseum. There was no mechanical issue as it relates to the cause of this catastrophe. 0. So the fact that you want to get into mechanical stuff is not relevant under 401, 403. It's highly more prejudicial than it is probative. And it wouldn't be allowed under 404B because that's exactly why would we have that rule? You'd keep it out.
What was your response?
Judge, the detective is just describing what she saw. I don't think she has made any sort of insinuations that any of the defendants put the electrical tape on, nor have I. She's just simply describing what she saw. So I don't know what else to say. If the court wants to strike the portion where she talks about the tape, that's fine, but she's just telling the court what she observed. Not every single sentence might be directly relevant to the cause of death, but she's just describing what she saw.
You're not objecting to striking the portion of her answer referring to the tape?
I guess, Judge, I'm not, but if I think it's unnecessary to object to every single thing that this detective says while she's generally making her observations. She's allowed to testify to what she observed. I don't think anybody has made an issue of this other than the defendants right now, and we probably all would have just cruised past it had they not stood up and object. So I'm not making an issue out of it. They are. So
I'll take it then that he'll stipulate that that has nothing to do with the cause of why we're here today, if he wants to go that route. I mean, unless I'm hearing something different in this courtroom, that's exactly what's going on, and I have no problem, Mr.
I
Kelsey.
don't have months and months of reviewing all of the discovery to know what's coming next. So I think I'm at a little bit of a disadvantage. But ultimately, if she's simply testifying about what she observed, and it's a sticking point for each one of you to ask whether it's important, whether it's applicable for the court to consider as a piece of evidence in this case that would implicate your clients, you're all going to have an opportunity to question this witness. But at this point, I don't know what I don't know yet. So I don't know that there's a big issue with her just testifying about what she's observed. Quite frankly, if no one attaches this bit of information that we've now made quite a big deal about to anything else, it's a non-issue. It's a non-issue. So I don't know what the issue is with her testifying about what she's observed.
With all due respect, Your Honor, with all due respect, you just heard yesterday, there wasn't a mechanical issue with this case, that we're not here for a mechanical issue. So anything about counters or cords being taped up with electrical tape, that's not why we're here. This is about a grounding cord. That's it. So that wasn't months and months. That was yesterday. And the other 2 witnesses that came in as experts talked about the same thing. So all I'm asking is we can narrow and focus this exam to the relevant issues that are here before us today. That's all. I have no problem. If you want to get into the observations, as long as everyone's in agreement, I have no issues.
I do have an issue, and I'd like to make my objection, is that relevancy in entering evidence on the record that is more prejudicial than probative is always an issue. This is being live streamed. This is being written
Well,
about.
it shouldn't be.
Okay, I take that back. This is being written about. This is going into the public. This is evidence that could continue to poison a jury pool. If we all agree that this isn't relevant evidence, why put it out there when we know what this case is really about? The case is really about the grounding. It's not about electrical tape on a cord, and it is a diversion. It's a red herring, and it's an opportunity to mischaracterize why we're here.
Judge, I guess my only response is I haven't done any of that, and the detective is just, I asked her what she saw, and she told the court what she saw. I think that it is unrealistic and not the intention of the court rules if I asked Detective Trigger what day it was, would everyone jump up and say relevance? Is that relevant, strictly speaking? I don't know, maybe not, but there are certain things that come in to understand the totality of what this important witness observed. So like I said, I mean, I can tell you, Judge, and I think counsel will probably, maybe in private, back me up. The only reason we're making a big deal out of this is because they objected. Otherwise, I would have just cruised right along. So I don't.
I'm going to allow whatever that answer was about the observations to stay in the record. I'm not going to strike it. I'll continue to listen to the testimony. I think it's reasonable that you're asking her what she observed. The court can consider what information is going to be utilized as the basis for my decision. I've listened to, it's now going on day 4 of this exam, and I'm being told it's not going to be done. So I would imagine that there's going to be a lot of things that have been testified to that don't end up having a whole lot of weight as far as my decision goes. And this may very well be one of them, but I don't see a basis for an objection being sustained here, so continue.
Thank you. Detective, go ahead.
Notice some distinct differences between the chamber involved in the incident and the other 2 that were present on scene. That, in addition to conducting some interviews that day, resulted in me drafting a search warrant to re-enter the location in order to conduct a more thorough search of the premises to secure additional records, documents, photographs, things of that nature.
Who was with you when you, and the search warrant, was that executed on the 1st?
It was.
Okay. Who was with you when you executed that search warrant?
Detective Sergeant Flood, Evidence Technician Officer Sam Sarah, Detective Youngkari, myself. I believe that was it. Present during the execution of the search. We were granted access back into the facility by a representative of the fire department, if I'm not mistaken, but that individual did not remain, they didn't enter the building and remain on scene with us during the execution of our search.
Okay. Was that the day, was it a different day that Mr. Malenchenko and Mr. Berman were with you?
That's correct.
Was that the 5th?
Yes.
Okay. On the 1st, when you went, did you recover certain items?
Yes.
Okay. Were they physical items? Were they like pieces of paper? Like what kind of stuff did you recover?
Paper, binders, training documents, different logs, certifications, tests, training materials, tablets, things of that nature, some billing items, consent forms.
Was that the day Thomas Cooper's patient records were recovered, or was that on the 31st?
So a copy of his patient records were provided to us on the date of the incident.
Okay. Thank you. And Detective, the big box over here, is that the stuff that was recovered on the 1st?
That is a portion of it. There's a smaller box underneath that also contains some items, yes.
Okay. Detective, Judge, I'm holding what's been marked People's Proposed 12. I will note for the record there are some sticky notes and stuff on here for our purposes, but before I publish this to the court at the request of counsel, I'll make sure all of those are gone, just so we're all on the same page.
Okay.
Detective, can I approach, Judge?
Yes.
Detective, I'm handing you a compiled set of documents that's been marked People's Proposed 12. Can you identify those for the judge? Like, what's that first document?
So it is titled Getting Down to the Nitty-Gritty, the must-have important stuff you really, really need to know in one place manual. And then there's a list of different subsections for that particular manual.
Is that the original copy that was recovered from the Oxford Center?
It is.
Okay, all right. And then the next document, do you recognize this?
I do.
Okay. Is this an original or is this a copy?
This is a copy.
Okay. And is it a copy of a document that was recovered from the Oxford Center?
It is a copy of a section of a document that was recovered from the Oxford Center, yes.
And on top of it, it's written Training Course Book 1 copy?
Correct.
Okay.
Might be two stuck together there.
No, thank you.
Okay.
And the next document, do you recognize this document?
I do.
All right. Is this another copy of a document that was physically recovered from the Oxford Center?
Yes.
Okay. Was this a standalone document, if you recall, or was this part of a larger subset of documents?
This was part of a larger set of training documents.
All right. And on the top is written Class 13. Is that correct?
Correct.
There's the other one. Detective Trigger, do you recognize this document?
I do.
Okay. Is this a physical, is this the original of what you recovered? Sorry, let's do this cleaner. Is this a document that was recovered from the Oxford Center?
This is a copy of a document that was recovered.
Okay. And then on the top it says training course book 2 copy.
Correct.
Okay. And finally,
Your Honor,
Detective.
I don't mean to interrupt Mr. Kessel. I do mean to interrupt. But
Yeah.
is when he uses the word "this," the record isn't gonna reflect what this is. Is it a document that's part of proposed 12, or is this something different? Because I see a folder up there as well.
That's fair. All of these documents are contained within the folder, and each title that Detective Trigger has read is a separate document that we're going to be specifically referring to.
Within people's proposed 12?
Correct. I spoke with the court reporter, and I think we thought the easiest way was to, as opposed to admitting all of those, referencing them, and then specifically admitting the compilation of things that we're going to go forward.
I guess my objection is when he says "this." I mean, if he could further write that the document purports to be its title, so that when we have the transcript later or when we want to use the documents, we know what this is. That's right.
So are you asking when he provides it to the witness to review, would it be preferred if he said this document entitled?
Well,
How do you want it to be identified for the record so it would be clear?
it's his exhibit, but I don't think he can use the word "this." He has to say, "This is a document. Can you describe it generally for me?" We get a general description, just so we know what this is. That's
Well,
and the record, if there's a reviewing court down the road, knows what this is.
Well, and I think, Judge, that's what I was doing by asking what each document was labeled as top. So there's the one that's called the nitty-gritty. There's the one called training course book 1 copy. The one called class 13. The one called training course book 2 copy. And while I pick out individual items that I want to draw the court's attention to, I will make sure that each document is referred to by its title,
I guess I'll wait and see, Your Honor. Thank you.
Okay,
if that works for the court.
I think so. I know that you were giving her the documents and then she was identifying what they were by reading the title, but I'm not sure if there's a better way to do it. Would it be preferred if they had?
I'm handing you proposed exhibit 12. Look at this document. It states the nitty-gritty.
Well,
Okay, great.
But they're all proposed exhibit 12.
I understand. Within each one, there's a section. It's trying to. I agree with him. It makes it sound. It's easier to put them all under 12, but there are probably 10 tabs within 12. This is give or take. Yeah.
12A, 12B,
Yeah.
12C.
Whatever it is,
Have her
just so I can
identify each one
later
as we
on.
go along.
I have them, so I
Yeah, and Judge, for what it's worth, they're all, I think everything that's, the titles that we have put on these are the titles that they are saved under on evidence.com.
The PDF.
Titles that counsel has been given, that's how I have entitled them. But I tell you what I'll do, if
Chris,
the court would like,
I have them all labeled anyway under 12.
They're all A, B, C.
You already have them.
I can just write down A, B, C, D, and E.
Let's just do that.
Yeah, that's fine, Judge. I'm happy to. You want me to just write these down, or do you want extra stickers? I can do it. You don't have to worry about it.
Do you want him to go back through each of the documents now using the subsection?
That would be useful.
It's fine, Judge. It shouldn't take
Okay.
long. Detective Trigger, I'm handing you what's been labeled people's, well, let me take a step back for a second. All of the documents that we have just gone over before, are these all either originals or copies of documents that were seized from the Oxford Center?
Yes.
Judge, I guess at this time I will move to admit people's proposed 12, and then I will go through and label them A through E.
Any objection?
For purposes of exam, no, as long as we have that A, B, so we know which document's being discussed. Thank you.
Yeah, it's same, and I think I have them,
I appreciate
I have no objection.
No objection.
No objection for
All right.
purposes of standard.
Thank you.
Okay. And for the, I guess I'll do this, Judge. For the record, Your Honor, Exhibit 12A is entitled Getting Down to the Nitty Gritty.
Okay.
Exhibit 12B is titled Training Course Book 1 Copy. Exhibit 12C is Training Course Book 2 Copy. Exhibit D is the Poseidon Safety Hyperbaric Training Facility Hyperbaric Medicine Course. And Exhibit E is entitled Class 13.
Okay. Does that mirror what you had, Mr. Flood?
Yes.
All right, so just so the record is clear, People's 12 is admitted at this time.
Thank you, Judge. All right. Detective Trigger. Now, do you know who drafted these documents?
I do not know. I guess I cannot say for certain who drafted it.
Okay.
I don't know.
Detective Trigger, for example, I'm going to draw your attention to this page in People's 12A. These are double-sided while everyone follows along, but this is...
I have to commit to a location with the microphone.
No one's ever told me I wasn't loud enough. I think this is page 16 of 12A.
Failure to the door locking.
No, if you go through the physical pages.
Oh, okay.
It's not.
Yeah, I got you. I'll find it. 16.
Yeah, I'll wait for you. Next page. There you go.
Thank you.
Detective Trigger, is there a large paragraph in bold font
Yes,
at the bottom of that page?
there is.
Does it say warning?
It does.
Could you read that into the record, please?
In the event of a fire in a monoplace chamber filled with 100% oxygen, it must be noted that there is not a realistic chance that the patient inside the chamber will survive. Given this stark reality, then the bulk of operational effort must be concentrated on prevention, in all caps, of the fire, and to eliminating ahead of therapy, to the greatest extent possible, a fire from ever starting. In the event of an unlikely chamber fire, response efforts must be centered on limiting the peripheral harm to the building, treatment staff, and other patients and guests within the center.
Thank you. Judge, can I freely
Yes.
throw? Thank you. Detective Trigger, I also want to draw your attention to, let me make sure it's the right page. Page 56. You can just look at photographs. There are a bunch of photographs. Keep going forward.
This one?
Yep.
You don't have these labeled.
Which document are you on?
The nitty-gritty now. Right there.
This one.
Yep.
Thank you. And what do you got this marked as in your exhibit?
This is 12A still.
No, what page?
Oh, it's page 56 of the PDF. That's how I was.
Okay, thank you.
Yep. And Detective Trigger, I've handed you another page of People's 12A. Are there photographs on that page?
There are.
And the bottom, is it right hand? Is there a picture of someone testing something?
Yes.
All right. What is it? Does it look like they're using?
It is labeled underneath, actually, and says the wrist grounding strap. It's an individual holding a wrist strap that is connected to a cord.
Okay. Thank you. Judge, so everybody can follow along, I am now on People's 12B, which is Training Course Book 1. It looks like this.
Yep.
And I guess you guys too.
You got it.
Okay. All right. Detective Trigger.
Can you show me that front page one more time?
Yeah, of course.
So, this is 12.
There you go. Right
Yeah. That'd be 12B under your campus.
there. I mean, I was just labeling them on the
I
fly.
got you.
All right, Detective. If I'm here, am I okay? Is the microphone? Okay, cool, thank you. Detective Trigger, this is People's 12B. On the third slide, there's a slide entitled Chamber Safety Director Course Objectives. Is that correct?
Yes.
What's the first bullet point on that?
Gain competent knowledge of NFPA 99, Chapter 14.
And Detective Trigger, you have been present during all the testimony, is that correct?
I have.
Is that NFPA 99, Chapter 14, is that what you recall Mr. Berman testifying about?
Yes.
And is that what you recall Mr. Melenchenko testifying about?
Yes.
Thank you. Oh, sorry, Judge, a lot of back and forth here. And Detective Trigger, on the bottom, slide 6, there's a slide entitled Anticipated Student Learning Outcome Continued. Is that correct?
Yes.
Could you read that into the record, please?
The entire slide?
Yes, please.
Okay. There are multiple bullet points. The first, identify the scope, content, and application of the hyperbaric chamber, electrical and communication requirements contained in NFPA 99, with special emphasis on facility level and mechanical system requirements. Second bullet point, describe the threats and methods used for fire prevention inside the chamber. Third bullet point, describe the key elements necessary to construct and execute a successful hyperbaric safety program. Next bullet point, describe the professional responsibilities of the administrative and medical staff in managing a safety program. Next bullet point, describe the procedures required to get electrical equipment approved for in-chamber use. The final bullet point, describe the procedures used in developing emergency procedures specific to a unit and safety policies for that department.
Thank you. Last one on this document. Detective Trigger, slide, it's labeled number 2 on that slide you see in the middle.
I do.
Okay. What's that slide entitled?
Why should we be so concerned about fire safety?
Okay, could you read that into the record, please?
Can you hang out for 1 second?
Sure.
You don't have these labeled.
That's how we got it.
Yeah, I understand. Which one is it?
If you go to the 10th page in that document.
What slide is that?
Does that say slide 2?
It's slide 2. It's the second slide after the Chamber Safety Director course orange slide with the Oxford logo top left. There's some astronauts underneath it on slide 3.
There's
This?
one in the middle.
Thank you.
Yep. Go ahead, Detective.
Multiple bullet points. First, our patients are in a confined space. Next bullet point, remember that even when the percentage of oxygen does not change, In all caps, the partial pressure increases with increased ambient pressure. Next bullet point, anything above 23.5% or a partial pressure of 357.2 mmHg is an oxygen-enriched environment. Next bullet point, all caps, there is a very good reason our planet has only 21% oxygen. Next bullet point, the 3 best methods of fighting a chamber fire are prevention, prevention, and in all caps, prevention. Last bullet point, did I say prevention?
Thank you. Moving on to People's 12C, which was titled Training Course Book 2. That one starts like this.
Right here.
Got it? Okay. Okay. Detective, looking at People's 12C, at the bottom slide, what's that slide entitled?
Chamber fires.
Okay. And could you read that into the record, please?
Multiple bullet points again. The first, have occurred in all types of chambers. Next bullet point, last reported fire 2017. Final bullet point, ignition source, static electricity, faulty wiring, light bulbs, friction toys.
Thank you. Detective Trigger, I am turning to it's page 7 of the document, but the bottom right has marked page 13. Is that correct?
Yes.
And this is slide number 39. Is that correct?
Yes.
Could you read that slide into the record, please?
It is titled Pre-Dive Checklist, again with multiple bullet points. First, remove all jewelry. Second, signs of cold or flu, and then there's a box to check yes or no. Next bullet point, remove prosthetics, contact lenses, dentures, hearing aids. Next bullet point, remove all cosmetics and petroleum products. Next bullet point, 100% cotton clothing only. Next bullet point, temperature less than 100.5 degrees Fahrenheit. Next bullet point, pre-dive instructions given. Next bullet point, patient voided. Next bullet point, medications given. Next bullet point, blood glucose greater than or equal to 120. Final bullet point, which is bolded, ground strap secured.
Yeah. No, it says there's one with a picture of like a finger on it.
That's the same she just read. All right.
Well, it's twice.
Yeah.
Detective, could you flip to the next page, please? And
Sorry, Judge.
thank you. Different page, marked People's 10. This is a different. Is this a different page than what you were just looking at?
It is.
Okay. The slide you were just reading, was that on the bottom of the page?
That was on the bottom of a different page.
Correct.
The graphics are similar on the slides above.
Okay. And what is that slide entitled?
Pre-dive checklist.
Okay. Are there similar things on this slide that you just read into the record from the other slide?
Yes.
Okay. At the bottom, what is listed on this slide?
Ground strap secured.
So in this particular document, the grounding strap being secured is referenced twice. Is that true?
Yes.
Detective, I am going to hand you People's 12D, which is the Poseidon Manual. Detective, there is a section in this page called static electricity, is that correct?
Yes.
All right. Is there a photograph of a child with hair that seems to be rising?
There is.
Okay. Have you seen something similar to that as part of your investigation in this case?
Unfortunately, I have.
Can you tell the court what you saw?
In the video of our victim in the chamber shortly before the ignition, his hair looks very similar to this photograph.
It looked like it's rising up from his head.
Obviously not this significant, but yes, it is noticeable.
Okay. Can you read, though, I think there's a paragraph with two numbered paragraphs there, is that correct? They're very short, 2 sentences?
Yes.
Can you read those into the record, please?
The first, in addition to the normal safety precautions of electrical voltage being routed into the chamber, the system must be equipped to safeguard against the generated electrostatic sparks within the chamber itself. Number 2, the patient who by normal movements within the chamber generates electrostatic electricity must be grounded to a metallic part of the chamber.
Thank you, Detective.
There's several pages.
Detective, I'm going to flip the page here. Is there a section of this 14.3.1.6.1.3 in this document?
Yes.
All right. And is there a exhibit down? Oh, excuse me. Hold on. Sorry. 14.3.1.6.1.3 that I'm pointing at right now, and that
Yes.
would be okay. And that's on, for everyone's edification, on the upper left-hand corner. It says 616.
Can you show it to us real quick?
Sure.
Are those your highlights?
No, but I can make sure that clean works. It's not a problem. I don't know. Detective, are these highlights? Are they yours?
Correct.
Okay, Judge, we'll get the court clean copies of these.
Okay.
The original copies are there. These, I was under the impression were being utilized for your reference specifically.
I got you. That's you're okay.
Okay, thank you. Thanks.
Detective, a line that's highlighted. Can you read that line, please?
In addition to monitoring prohibited items, the following items should be verified.
And can you read what that list of items that should be verified is?
1, patient identity. 2, pre-treatment orders. 3, appropriate safety measures. 4, appropriate staffing. 5, appropriate textiles. And 6, patient grounding.
And the last page that we'll be talking about on this exhibit, the upper left-hand corner, it indicates page 618. Is there you highlighted a portion in here, is that correct?
I did.
Okay, can you just read that portion into the record and then describe the photograph below this portion?
In Class A and Class B chambers with atmospheres containing more than 23.5% oxygen by volume, electrical grounding of the patient shall be ensured by the provisions of a high impedance conductive pathway in contact with the patient's skin. This high impedance conductive pathway is usually accomplished with a grounding strap, which is shown in Exhibit 14.37. Exhibit 14.37 is a wrist strap with a cord attached to it that appears to have something similar to a headphone jack at the end.
Okay. Thank you. Detective, I want to talk about the photograph that you just had a look at. Prior to this case, did you know anything about hyperbaric treatment?
No.
No. Did you know anything about grounding straps?
Absolutely not.
Okay. The photograph that was in the document we just discussed, have you seen one of those grounding straps before? Not before this case, but before today.
Before today, yes.
Okay, tell the court where the first time you saw one of those was, please.
During the execution of a search warrant at the Oxford Center Troy location on February the 5th, there was a drawer within the laundry room. When we opened it, it contained things like half-eaten bags of chips, tape, things of that nature. I would describe it as a junk drawer. In the back, there was a plastic container. When we opened that plastic container, there were several wristbands similar to that, with some cords attached. They had, I guess, what I would describe as an oxidization of white film on them. It appeared as though they had not been used or touched in quite some time.
Okay. And Detective, you have reviewed all of the photographs, or I should say, have you reviewed all the photographs that have been submitted to this court for evidence?
Yes.
Okay. The photographs that are People's Exhibit 2, the photographs that were taken on February 5th, is that, those photographs, are they representative of how you found those grounding straps in that drawer?
Yes.
I want to just approach with one more document, Judge. This is 12E. This is the one entitled Class B.
What's it entitled?
Sure. I'm sorry, my handwriting. It's Class 13. This is part of the full training classes. The first one says Chamber Director Safety Course. Yeah.
Okay, thank you.
No problem.
This part is part of 12.
This is 12E.
Okay, thank you. Sorry.
No, it's okay. Detective, again, I want to draw your attention to page 10, the top slide. Is that entitled Pre-Dive Checklist?
Yes.
All right. And is there, again, another list of things similar to the list that you've read before?
It appears to be identical.
Okay. And once again, is the bottom bullet, is grounding strap secured, also supposed to be checked?
Yes.
Safety director. Chris, can I just see that one last time?
What, you want the whole thing?
No, just the, you said, is it safety director course? Is that what you have?
This one, that's just the front slide of this.
I don't have that one.
This is, we can go for
I got it. But it's the director course, safety director.
Well, so
Training course.
the slides are not what they are saved as in evidence.com. So when I call them, is what they're saved in evidence.com.
I got you.
Yeah,
But I just want to make sure I understand the title.
100%.
I'm not a safety director.
I have two entries.
Thank you.
No problem. All right, Detective. And now for real, the last one. This is page 13 of that document. Again, the bottom slide, does that appear similar to a slide that you've looked at earlier?
Yes.
Okay. There's a finger on it with a piece of string. Is that correct?
Yes.
All right. And this slide is entitled Pre-Dive Checklist.
Correct.
And again, what is the last thing that is bulleted on that page that should be checked?
In bold text, it says ground strap secured.
And does it appear as though this particular slide is repeated in multiple instances?
That identical slide is in a separate training document that we acquired, yes.
And so, based on your review of all of these materials, is the note that a patient should be grounded, is that repeated in the materials that you recovered?
Extensively.
All right. Is the danger of static electricity repeatedly discussed?
Yes.
Is the danger of fire in a monoplace 100% oxygen chamber discussed?
Yes.
All right. Are there have you seen warnings?
Yes.
Okay. Have you reviewed the manual, the Seacrest manual in this case?
Yes.
All right. Were there warnings in that document?
Yes.
Detective, were you present? Were you present on the 5th with Mr. Berman and Mr. Malenchenko when they did their review of the Oxford Center?
I was.
Okay. And were you present during the pillow pull-out and the static discharges from the pillowcase?
Yes.
Okay. Where were you when that happened?
I was standing right next to the gurney as it was taking place.
Was Mr. Berman present in the area as well?
He was.
Okay. What was his reaction?
He was, the best way I could describe it is anger. Frustrated at the fact that that was occurring on an item that was on a gurney of a neighboring chamber.
Detective, did you attempt to determine whether or not any of the defendants had active certificates regarding hyperbaric treatment?
I did.
Okay. Were you able to find any such records?
Mr. Mosteller had a
Your Honor, I'm gonna
current
object.
certification.
I'm going to object because I think we've already heard testimony that certification isn't required, so I'm not really sure why that's relevant. I believe Mr. Malenchenko actually testified to that.
Judge, it's part of her investigation as to what it was she found. Again, it's part of the active case. And even if it wasn't required by statute, it's still something that she can testify to and is still relevant.
Why is it relevant? What fact does it make more or less likely? I don't understand. If it's not a requirement, why does it matter if somebody's certified or not?
Well, Judge, again, Mr. Mosteller, I think, was the one who did have an active certification.
From my recollection, that is correct.
Well, I'm sorry, but there's an objection pending.
No,
so
no,
I
I-
think that's appropriate.
Go ahead.
Respectfully. But, Your Honor, here's the thing, right? I mean, Mr. Kessel can say to the court, I'm just asking for information about her investigation. But there's a nefarious inference to these certain things, right? Like the fact that there was tape on the back of the chamber. She's only noticing it because she thinks there's something wrong with it, right? There's something bad action related to it, just like there's some bad action that people aren't certified, but it's not required. It's completely irrelevant.
If I can say here, I'd ask Mr. Kessel to make an offer of proof to you what is he intending to prove with these little things that he keeps pulling out. Because I think what he's going to argue later, when the experts have said there's no mechanical problem here, when Mr. Malenchenko testified at Beaumont, he wasn't even certified and he was working as a technician, but they keep pulling these things out to try and paint some sort of picture. And I don't know what Mr. Kessel is going to argue to the court, but he ought to say what is the offer of proof here from him as to why this is relevant. Not that she did an investigation, we know that. But what is this particular or these particular pieces of evidence, what did they go to prove or disprove?
I was waiting. It's Judge. It seems like you want to.
Okay. So, on this particular question, so I'm going to try to limit my response to just simply the objection on this particular question. But as part of what the court has to consider to determine if the people have established probable cause to bind the case over to the circuit court, there's an element that I think some of the testimony will potentially be considered for as it relates to what was known, what was not known, what was intentional, what was not intentional. So someone's training, although it's not required for certification, I did hear that testimony, but someone's training as it relates to the use of the machines and the safety requirements, this seems to be important to the board.
Go ahead.
I think the court respectfully is mistaking saying training equals certification, and those are not two of the same things. Someone can have adequate training and not be certified, as evidenced by Mr. Malenchenko. Lomachenko's testimony that he was diving patients without certification, and there was nothing wrong with that.
I agree, but I also think that on the flip side, someone that's been certified would have to have had training to achieve the certification. So
Right,
I
but
can look at it in a different way. I'm not finding that I would have to establish that someone has to be certified to operate the machine.
No, but they're going to make the argument, presumably, because otherwise why would you bring it up, that the lack of certification reflects a lack of training. And that is just simply not an accurate or fair inference to make or to argue. I don't know if my brother and sister counsel agree with me, but that can be the only road that this is going down, and it's inappropriate.
Is that part of what you were going to offer to the court, and that's why you're seeking this information? I was looking at pretty much the opposite here. I don't think that anything that I'm hearing is going to demonstrate to me so far, based on what I've heard from the experts, that certification is required.
Sure. I don't disagree with that, Judge. I guess I'd rather not put my whole argument out there, but
Right.
Ms. Sharon's saying what I was going to argue is really not how I particularly was looking to frame that argument.
That begs the question, then, why is it relevant?
Right.
The 401 just deals with, is there a material fact in question that moves the needle one way or the other? The fact of training and certification, that certification doesn't move the material fact one way or the other for the relevance of this question, for the relevance of why we're here. Because I don't know how else to say it, but if you want to go to Lara and see how many people were certified there, does that make it relevant one way or the other for a murder 2 charge? No. No witnesses came up here and said that. As a matter of fact, the guy that was trained, that was an expert, wasn't even certified. He said, I got trained by experience. And then later on became certified. And he was doing this. So what material fact does this move the needle on? That's my objection.
Your Honor, if I may, I'd like to hear Mr. Kessel put his theory of relevance for. I know the court's telling us, but he's the one who's proffering the evidence, and I'd like to hear what he has to say about all of these little nuggets that he's laying out about that really have nothing to do with why we're here.
Well, Judge, I'll go in reverse order. I think the slides that we have gone over are not little nuggets. It is point blank proof that the Oxford Center in their own possession had documents talking about how important patient grounding was. And that is why we are here, because Thomas Cooper was not grounded, and he died because his chamber exploded with him in it, because the defendants, some part, decided that they knew better than what the experts have shown, what their own teaching materials have shown, what the user manual has shown. So the fact is, these people were operating this facility in an incredibly dangerous manner. And the fact that they were not certified, while maybe not required by law, is still relevant to the way that they were operating this clinic.
And many of them went in the chamber the very same way.
I don't know that that's relevant at all.
To intent?
To intent?
Judge, I'm going to go in the chamber.
I haven't heard that testimony.
You did.
Except from Housey. So at this point, to this argument, I don't understand why we're having this huge back and forth on this point.
So just to clarify, because I feel like maybe Mr. Kessel's response reflects maybe a slight misunderstanding of what my objection is. I don't have a problem to, reading a portion of an exhibit that's already admitted. That's not my issue. My issue is the additional question that came afterwards was, well, did you find that any of these people were certified? It's not relevant. It is intended to cast aspersions, right, against the Oxford Center that their HBOT techs, am I using the right phrase?
Yes.
Are not certified, even though it's not required, and even though that is not the only way that a person can be sufficiently trained to operate these machines under lawful treatment. And so when he elicits that testimony, with all due respect to Mr. Kessel, I can't imagine what other reason it would be other than to say, look at this, you'll excuse my language, half-ass operation that isn't doing things the right way, when there's no requirement that they be certified, and there's no evidence that you can't be sufficiently trained without certification. It is an attempt to cast aspersions against how this business was run, even though there's no requirement for it, Your Honor.
Just to buttress that last part, I'm sorry, Mr.
No, go
Russell,
ahead.
The fact is, it seems to be making an indelible imprint on your mind, which is exactly what it shouldn't be doing. We shouldn't even be in this. It's not relevant to this case. We shouldn't conflate training with certification. That's what's going on. You are, if I hear you correctly, Judge, and certainly correct me if I'm wrong, you're saying it's relevant to something, and we don't have a clue what it's relevant to because it's not part of this case.
I assumed that the testimony that was being presented for the last hour or so was to establish that there was information available to all of the employees about the safety protocols, and that there was some question about certification, which I'm assuming was also to establish that someone that's certified would have been exposed to the same training material. That's it.
Yeah.
There's nothing that the court is deciding about whether certification is required, but I still find that to be relevant. I have no idea for what purpose it will serve me. I haven't gotten to the end of all of the testimony at this point, but to make a decision based on what I've heard so far, I can't reach the conclusion that this is an irrelevant question or answer that I would have to strike from the record.
Can I have something to add based on what you just...
I don't know that I need a comment
Or
to the ruling.
it's a support of our position, of the position of why this is not relevant. May I?
I think I've heard enough, quite frankly. I don't need a comment on the ruling. It's a simple question about whether or not she came to find out if anyone was certified.
So I can't speak to the objection?
No.
Sorry, Judge, just 1 second, please. Detective, as part of your investigation, were mobile devices seized from Mr. Mosteller and Ms. Peterson?
Yes, amongst others.
Okay. And were there also other hard drives and other electronic devices that were seized?
Yes,
Okay. Are those still in Troy's custody?
they are.
Okay. Judge, I have nothing else. Thank you.
Do you guys want to... Judge, can we approach?
Are we still on the record, Judge?
Yes.
Okay. Detective, this afternoon, I'm going to lead a little bit here. Heads up. Detective, this afternoon, some of the defense attorneys made you aware that they may not have had all of the discovery material. Is that correct?
That is correct.
Okay. Can you explain how you upload things to evidence.com and how that gets distributed?
Yes.
Please do.
So throughout the progression of the investigation, we upload items to evidence.com. When it comes time to share those items, either with outside prosecuting agencies or defense, a share link or a download link is created.
Or to me, by the way, right?
Yes, correct.
Yes, okay.
Yep, to either side. From that point forward, when additional items are added to the evidence.com case file, I am prompted with an opportunity to select to share those added items with the parties that they were previously shared with, which is what had been done in this case.
Okay.
At the time that everything was provided to defense, I believe there were 180 or 181 items on evidence.com. Since that time, I believe it is 8 or 9 items have been added, most of those being specific to bond violation situations
Okay.
that did not include all defendants.
Sure.
The fire report that was acquired after the fact, things of that nature. As it relates to the case report, there were additional narratives that were completed after a taint team was put together as it relates to the electronic devices. Those individual narratives were parsed out and provided to defense at the time that they were authored by each investigator that authored them. So they were not included in the original continuous case report, but were provided after the fact.
Okay. To your and you indicated that based on, do your records show that these links or this material was sent to defense counsel?
Correct.
Okay. And just so I'm clear, is your understanding is the only things that were added after what date?
So the initial share, I think, was sometime in March.
Mm-hmm.
There were items added afterwards, and if I recall correctly, those were exclusive to the bond violation situation.
Sure.
I think there was an updated version of the case report that was added that included supplemental reports like we had discussed, and I believe that was it.
Okay. And you said the taint team documents that Mr. Gleason and I sort of asked the department to create?
Yes, that's correct.
Okay.
And then narratives related to those other situations that we had discussed.
Sure, yeah, but bond violations aside.
Yes.
Bond violation stuff, the taint team reports.
Correct.
Anything else that you know of that was added after, I think, May?
The fire report was sent to us by the fire investigator. It was uploaded via evidence.com, so
Okay.
that would have been added to that case file.
Which the record should reflect. I forwarded to counsel about 20 minutes after I got it.
And I believe the autopsy report may have also been included in that as well.
Which I believe
Which
I
was
also,
emailed.
sorry, yeah, which we also personally shared with counsel. Judge, I don't know if the attorneys want to cross-examine Detective Trigger on this point, or if the court has any questions. I'm not really sure how you want
I
to.
think they would be better suited to ask the questions if there's something she's identified that came after the fact that they want more information about.
Sure.
Leave it to them.
Yeah, absolutely.
So the court's telling to me to begin cross-examination.
Well, I'm trying to determine if there's a reason we shouldn't.
Understood.
And so I know from what I've just heard, the information regarding the bond violations probably would not be relevant. The information regarding the team and the statements, I think we've all reviewed those because I had to consider them in making a ruling on a motion, so that's not something we haven't seen. The fire report, obviously, I'm assuming that's an important piece of evidence, but it sounds like you separately received that. And the autopsy report, potentially another piece of evidence that's important, but it also sounds like you've received that. So if there were other things that she identified that you know you didn't receive until just 30 minutes ago that are going to present an issue, I'm giving you an opportunity to question her about that. But I don't really know what to question her about because it sounds like a lot of the additional information you may have received it separately. But if there's something else that you didn't receive until just now that we need to ask her questions about before we determine how to proceed, you can.
Let me see if I can do that, Your Honor.
Okay.
Detective Trigger, may I approach the witness?
Yes.
Detective Trigger, I'm going to represent to you that the first Troy Police Department is the one that I received on March 16th, 2025. That's the creation date.
Correct.
See that? Okay. The document that you emailed over to my office, which happens to be in Troy, and somebody brought it over, is 12/2/25 and 12:13 p.m. That's today, right?
At your request, yes.
Okay. All right. Now, in the March document, the last supplemental report is number 36. Is that right?
Yes.
Okay. The last supplement number in this one, which I haven't had a chance to read this, Your Honor, so I apologize. Some of which I recognize from the bond hearing. I will concede that. But the last one is 62.
Yes.
So there's about 30-odd additional supplemental reports that are added, right?
So if you look at some of those additional items,
Sure.
you'll see places where they are blank, but they still account for a number.
Right.
Attachment report only. Those are documents that would have been added to evidence.com that through our records section are presented to an individual within our investigation section who then scans them in and attaches them to the Clemens report.
All right. So, for example, supplement 49 by Detective Flood, attachment only. That's some document that's being stored at evidence.com, right?
Correct.
That's not part of the report that I showed you.
Correct.
It's not formally attached like I talked to Detective Whiteside about you.
Correct. It's in evidence.com.
All right. So if we didn't get the evidence.com shipments, all right, after March 16th, we wouldn't have access to those supplemental additions, right?
It's assuming you did not receive access to it on our end. It shows that those items were sent to the email addresses that you guys had provided after that date.
Okay,
But if you guys are saying you didn't get them, then there may have been some sort of error in getting them to you from evidence.com, but they were provided.
all right. But all I'm saying though is when we see some of these additional supplements,
Attachment report only. Yep.
and those are early on, that's supplement 6 and 7.
Correct.
Okay, some of those we might have gotten because they would have been provided when initially in March. But to the extent that the new, what I'll call the new report, today's report, references supplemental attachments.
Correct.
Okay, that occurred after March, right?
So I guess to provide some additional clarification here.
Sure.
As I write the search warrants that I write,
Yep.
when they are signed, they are immediately scanned in and uploaded to evidence.com as an attachment that you all were provided at initial discovery.
Okay.
After the fact, many of those documents are scanned in and attached to the report in Clemens because that is the way that we did it prior to evidence.com. Each time one of those items is attached, a separate supplemental report number is created. So it's duplicative.
Okay. But when we have, for instance, and I'm just going to move on, and Judge, if I'm wasting time, please tell me. When we have, for example, 60, the point opened in error, no work completed, so that means nothing happened.
Correct.
Okay. But further back, we have, say, 39, which is not included in the March report. It says an attachment-only report.
Correct.
So you would have done something with a piece of documentary or digital evidence, right?
It would have been a document that already existed, that would have been added in Clemens. It already existed in evidence.com.
Okay, but if we didn't get the evidence.com notice that it was there,
It wouldn't have been, so it would have been one of the original documents you received. It would not have been a document that was created after the date that we shared everything with you. If you look through here,
So-
you can see in the initial report, you will not see all of the search warrants attached to this case report.
okay.
There may be one or two search warrants and affidavits where I completed 10 at minimum.
But you'd agree with me, these attachment-only reports, 49, 50, 51, I didn't get that in the March report, right? It's not here.
It's not in the Clemens report. It's on evidence.com. That is correct. Yes.
So why are you, I guess the question I'm asking is, why are you attaching it after the fact?
So that is the way that they had always done things, is to attach it
All right.
to Clemens.
So what you're telling me is that after March 16th of 2025, when this was created, no new materials were added by you to evidence.com that would have should have been alerted to us that was additional material.
No, sir, that's not what I'm saying.
Just testified what it was, correct?
It's the other way around. Everything in Clemmis, with the exception of the reports related to the taint team, the reports related to bond violations, are items that you guys have, the narratives themselves.
What I talk about, though, is not just the reports, but the evidence, the stuff you seized. There's nothing added to evidence.com after March 16th.
As far as evidence,
Yes.
no, not related to the investigation.
Okay, so when I go to evidence.com, when I go back to my office today, I'm not going to see anything new being added after March 16th.
That is not bond violation, autopsy report, narrative related to taint team or fire report related, no.
Okay.
Or I think in those MSP reports too.
Yes,
Yeah.
fire report, I should have been more specific.
Thank you.
I can proceed.
Okay.
All right. Detective Trigger, you were the officer in charge of this case?
Yes, sir.
Okay, and what does that mean to be the officer in charge?
I was the primary investigator on the case.
Right. You have responsibilities as the officer in charge?
Yes.
And what are those responsibilities?
I mean, we divvy up tasks amongst all of the investigators upstairs for a case of this nature, but primarily overseeing case reports that are documented, drafting search warrants, conducting interviews, acquiring charging documents, swearing to those charging documents, being here today and coordinating court appearances, things of that nature.
Anything else?
Reviewing video, acquiring evidence, tagging that evidence, potentially returning property to individuals who come to pick those items up, receiving property from individuals who may have to turn it in based on a court order, reviewing phone content, reviewing laptop content, talking to experts that we had dealt with, conducting supplemental interviews, coordinating with the prosecutor's office. It's a vast array of tasks depending upon the case.
But you're the person in charge of the investigation, is that fair?
That's correct?
And you also coordinate with the prosecutors, right?
Yes.
Okay. This is not your only case that you've handled as an officer in charge?
No.
Most of the crimes you investigate are handled by the Oakland County Prosecutor's Office, is that fair?
I've had a decent amount that have kind of been spread around, but primarily we deal with the Oakland County Prosecutor's Office.
It's fair to say more than 90% of your cases are handled by
That would be safe, yes.
Okay. Maybe even more than 95%?
Sure.
Have you worked on any other cases with the Attorney General's office before this one?
Yes.
The purpose of an investigation certainly is not to convict people, is it?
No.
And you want to be fair in your investigation, do you not?
Yes.
You want to get all of the evidence, right?
Absolutely.
If it's positive or negative, you're just there to gather information, right?
Correct.
And you want to make sure you gather all the information, right?
Yes.
You want to make sure you're thorough, right?
Yes, sir.
You're fair.
Absolutely.
You don't jump to any preconceived ideas about whether someone's responsible or not, right?
Correct.
Okay. So in this particular case, the death of the child occurred on January 31st, right?
Yes.
Okay. Did you receive any contact from the Attorney General's office, an agent, the same day?
Yes.
Okay. And
For clarification, I did not speak with that individual. My supervisor did.
okay. Someone at the Troy Police Department received a call the same day from the Attorney General's office, an investigator, right?
Correct.
Did you speak to that person?
Not that day, no.
But you did soon thereafter, did you not?
Yes.
All right. And that investigator made some statements about the Oxford Center and Ms. Peterson to you or to the Troy Police Department, right?
Correct.
Okay. Did that investigator provide you or the Troy Police Department with any of his investigative reports?
Yes.
Are those included in the evidence.com materials that were supposed to be provided to us?
So there were statements that, I guess, okay, we did not include anything related to their fraud investigation in ours, no.
Okay. Were you given those reports?
Full reports, no.
Were you given any portion of those reports
We were given several written statements.
from witnesses?
Correct.
Some of the same witnesses in this case?
No.
Different people.
Correct.
But those are in the possession of the Troy Police Department.
Yes.
Those are documents that you acquired from a fellow investigator at the Attorney General's office, right?
On an unrelated investigation, yes.
Okay. Unrelated investigation.
Yes, sir.
And that's why they were not included in the report. Is that fair?
Correct.
Okay. So that report is completely unrelated to this case.
Yes.
All right. Now, when you went to the scene the first day, items were collected, right?
Yes.
Did you have a search warrant?
On the day that the incident
Initial-
occurred?
Yes.
No, sir.
Did you have consent to seize anything?
Yes.
And who did the consent was given to you by?
Jeffrey Mosteller gave consent to Detective Barrett.
To acquire the material that we've discussed with Mr. Kessel. Is that fair?
The copies of the items on the 31st, those
Right.
3 different items, yes.
All right. Now, in the course of your investigation, you interviewed a number of people.
Yes.
At the time the charges were issued, were you aware that Tammy Peterson had personally used the chambers without a bracelet?
Judge, I'm going to object for relevance.
I think it's absolutely relevant, Your Honor, that the issue here is second-degree murder. And the standard is a depraved heart. And
Just a second.
it's a depraved heart. And the court has heard evidence at the prior preliminary exam that Ms. Peterson and her family members utilized the chamber without the grounding strap. And I'm asking whether this witness knew that as part of her investigation prior to seeking charges for second-degree murder. Because I can't see how anyone can conclude that a person knowingly created the risk of death would subject herself or her family to that same risk if she knew that risk existed. It is directly relevant to state of mind, and it's directly relevant to whether this detective made any type of inquiry or learned that information.
Okay, did you want to respond?
Judge, I was just reviewing some case law and some statutory law. Judge, Judge, I'll leave it in the course of discretion for the moment.
Okay. If she can answer the question, she's free to do that.
Did you have any information or learn any information prior to the issuance of the charges in this case that Ms. Peterson had used the hyperbaric oxygen chamber without a grounding strap?
I do not recall when I received that information, but I do recall hearing about that.
Okay, prior to the issuance of the charges?
I genuinely do not recall.
Is that contained anywhere in your report?
I don't believe so, no.
Okay. Did you receive or learn that Ms. Peterson's family had used the hyperbaric oxygen chamber without a grounding strap?
Again, I remember being advised of information of that nature. I do not recall when I received it.
All right. But that, you would agree with me, is nowhere to be found in your police report?
Which would lead me to believe that I received it after that those charges were authorized.
All right. So had you learned that information prior to the issuance of the charges, you would have included it as a supplement in your report. Is that fair?
I would assume that may have been something that I would have referenced.
Okay. All right. Now, when you went to the scene initially, sounds like a lot of detectives went to this scene on the 31st.
Yes.
And you'd agree with me that the entire Troy Detective Bureau does not go out to every crime.
That's correct.
Okay. But a fair number went to this one, right?
Yes.
And was that because of the information you received about what had occurred?
It was because we heard that there was a possibly dead child. We generally all respond to something of that nature.
Okay.
It was also because it occurred at approximately 8 a.m. when the vast majority of us are still contained in the office and haven't gone out to do follow-up elsewhere for the day.
All right. But the fact that a child was involved motivated a fair number of the detectives to go that day, true?
Sure.
The Attorney General's investigator also provided you with names of witnesses. Is that fair?
Yeah. Yes, that's correct.
All right. And you identified them initially in the report as confidential informants.
That is correct.
Now, does Troy utilize confidential informant agreements?
We do.
And were confidential informant agreements executed for these two individuals?
Yes, they were.
Now, those individuals are not confidential anymore, are they?
That is correct.
Have those agreements been included as attachments anywhere in the evidence.com or in your report?
No, sir, they were not.
Okay. You still have them, though, right?
Yes.
When were they executed?
I couldn't give you the exact date. I'd have to reference my case report.
Well, where in your case report it indicates that they were signed up as confidential informants?
It indicates that I had a conversation with them on a particular date, and then that we went and retrieved written statements from those individuals. On the date those written statements were retrieved, those agreements were signed.
All right. And they are dated?
Which
The
thing?
confidential informant agreements are dated.
I believe so, yes.
Was that before or after those individuals testified in administrative interviews with the Attorney General's office?
Before.
How long before?
I couldn't give you an exact time frame.
These two individuals wanted to be confidential, is that fair?
Yes,
And so as a precursor to their involvement, that you had them sign those agreements.
correct.
In terms of the agent who provided you, from the Attorney General's office, who provided you that these witness statements or the witnesses that you made confidential informants, were you provided any reports from that special agent from the Attorney General's office about his activities?
I don't understand the question.
Sure. Well, the detective, the special agent at the Attorney General's office, do you remember his name?
I do.
What is it?
Lewandowski?
Lewandowski.
Yes.
Lewandowski has to learn somewhere that these people who want to be confidential informants exist, right?
So he provided us with the name of an individual who had information
Right.
about the people who became confidential informants. So
It's-
Mr. Lewandowski did not give us the names of those two individuals.
Okay. But did he provide you with any reports about what investigating he was doing that led him to be able to do that?
Like I said, we received several written statements from witnesses from their investigation, but I did not get a full case report as it relates to that.
Did you request a report from Agent Lewandowski?
No, I did not.
The Secret Service was used in this case. You're aware of that?
Yes,
Okay. Do you have written narratives from the Secret Service?
we do not.
Did you request those?
We did not.
The Secret maintenance records, you were the one to request those, right?
Yes,
You prepared a memo to Secret as to what you wanted, right?
correct.
Okay. Is that memo attached to the report somewhere?
Yes,
And it's in evidence.com?
yes,
Okay. Did you request maintenance for all three chambers or just one?
just the one.
All right. And when you got reference, it's a bad question. Well, you got the materials back from Secret, right?
Mm-hmm.
So,
Yes. Excuse me, I'm sorry, yes.
The court reporter's going to yell at me. She's
No,
not going to yell
no,
at you.
that's my fault.
All right. So you got them back. They were provided to you by the attorney, Mr. Cook, who we saw sitting with the Zoom with his client, right?
So they were uploaded to evidence.com by the gentleman who was the witness yesterday, not by Mr. Cook.
But you did have contact with Mr. Cook?
I did.
Okay. And that preceded those documents being uploaded?
So, yes,
Okay.
yes.
Now, you saw Mr. Flood's analysis of the records and the number of dives that occurred in a very short period of time. You remember that testimony?
Yes, I do.
All right. Did you see that during the course of your review of those documents, that sudden jump of thousands of dives?
I don't recall taking note of it, no.
There were maintenance individuals whose names were in those reports, right? The people who came out to Troy to look at these chambers, right?
Yes.
Did you interview any of those persons?
So there's one individual named Ray Furman, I believe. He did one of the early on maintenance. He was the first person that we spoke with at Seacrest because he had a different role. But outside of that, we did not interview any of the other technicians that conducted maintenance on those chambers.
Did you inquire from Seacrest who those people were?
Outside of the names that were provided on the documents, no.
So you did no investigation with respect to the actual individuals who came to Troy to look at those chambers on behalf of Seacrest. Is that fair?
That is fair.
The two individuals, the experts that you've heard them testify, those are the two guys, Malchenko and Berman, right?
Yeah,
Those names were acquired by Lieutenant Clark from your department, right?
that is correct.
And he's in the Detective Bureau as well?
Yes.
So you did not have any role in identifying those two individuals?
No, I did not.
But you did have you did participate when they came to town to go over to the Oxford facility in Troy to look around.
Yes.
And prior to that, they were at your department viewing the video.
Correct.
And you heard their testimony about having a little disagreement about where the spark was. Remember that testimony?
Yes.
That occurred in your presence at the Troy Police Department, right?
Yes.
There is nothing in your report that discusses the disagreement that Mr. Berman and Mr. Malachenko had with respect to that little issue, correct?
No, there's not.
Okay. Was that conference recorded in any way?
No.
Was it memorialized in any way, other than a very short paragraph in your report?
No.
How long were they there at the Troy Police Department?
I mean, hours.
Hours. And yet, we get half a paragraph in your report.
Correct.
Now, who had custody of the facility itself, the police department or the fire department?
The fire department.
Okay, so you had to get the fire department's approval to go in, right?
They allowed us access to the building after we acquired search warrants.
Yes.
Yes.
So you get the search warrant and you have to get the permission of the fire department to open it up, right?
They assisted us so we didn't destroy a lot. We are still able to go into the building with that search warrant. But yes, they allowed us access.
All right. So that we didn't destroy a lot. That's your testimony,
A
right?
lot.
A lock.
Correct.
L-O-C-K. All
Yes.
right. Okay. Did the fire department object to your presence prior to them performing a cause and origin examination?
No, they did not.
Okay. Did they advise you of what the NFP 921 said about conducting a cause and origin investigation?
No.
They just let you in.
With our search warrant, yes.
All right. At some point in time, you prepare a memo returning the control of the facility back to the fire department. Remember that memo?
I did not.
Okay. Did a detective at the Troy Police Department do that?
Sergeant Flood did, if I'm not mistaken.
All right. When did the custody of the facility move from the fire department to the police department?
I do not know the date that occurred.
All right. Is there a memo that reflects the custody of the fire department being transferred to the police department?
Not to my knowledge.
Was there a reason that occurred?
The transfer of the scene?
Correct.
Not that I've been made aware of.
I'd have to ask Detective Flood.
That's correct.
The scene as you went in with the experts, stuff was moved around, wasn't it?
While we were there?
Yes.
On that occasion, yes.
All right. And even on the first day, the day of the fire, it's my understanding that in the Gurney area, a fire reignited that the fire department had to put out, right?
That sounds familiar to me.
Okay.
Yes.
And so that affected the scene as well. They had to fight a second fire in the Gurney, right?
I would assume that would have been the case. I was not present when that took place, and I was not there when it occurred.
All right, so you don't know what caused the second fire to start in the chamber after the fact?
No.
Chamber 2, where this boy had been burned, a second fire started, and you don't know why it started. Is that fair?
Before right now, I was unaware that a fire that they actually had to extinguish had occurred in that chamber after the initial fire.
And that's not, and that's why it's not in your report,
Correct.
right? Okay. Because you didn't know that, right?
Correct.
So we get the scene affected by the second fire being put out. You go back with the experts and move stuff around. Do you go back again to that area with another search warrant?
So we went back on the 1st of February to retrieve records. We went back on the 5th of February with the experts. And then I was not present, but investigators returned, I want to say maybe on the 12th in reference to the DVR.
Were investigators from the Attorney General's office present for all of these activities?
None of them.
They were just feeding you information?
I don't understand the question.
Sure, they were giving you names of people to talk to?
They provided us names, yes, throughout the course of the investigation, absolutely.
Okay. Yeah, but you don't have any reports from the Attorney General's office about how those investigators acquired the identities and the names to give you to interview, right?
That is correct.
Generally, when you are seeking to have a prosecutor authorize charges, you present the case to them for review. Is that fair?
Yes,
Was that done here?
through evidence.com.
Okay. And it was given evidence.com to the Attorney General's office rather than the Oakland County Prosecutor's office. Is that fair?
Correct.
Is the Attorney General's office currently prosecuting any other murders in the city of Troy?
Not to my knowledge.
Judge, I know she's answered, but at this point, I'm going to object to the relevance.
Well, Your Honor, clearly a choice was made to go to the Attorney General's office after a call they received the same day, so I'm trying to figure out why this didn't go to the Oakland County Prosecutor's office, which one would expect in a murder case in your jurisdiction.
And as many people have pointed out, that is not relevant to the death of Thomas Cooper, which is my argument.
It might be relevant to the charges that were issued, Your Honor.
Based on, yes,
The
we
question
did
is
offer.
whether or not there are any other cases being prosecuted by the Attorney General's office in the city of Troy, murder cases. I don't know that that's relevant. So I'm going to sustain the objection.
After the Attorney General's office issued the charge, you have to go to court and do what's called a swear to. Is that fair?
Yes.
And that's where you're placed under oath, right?
Yes.
And you understand that you have to provide truthful information, right,
Yes.
about your investigation
Correct.
to justify the issuance of the charges. Is that fair?
Correct.
In that swear to, you indicated to the magistrate that conversations with investigators at the Attorney General's office made Troy investigators aware that the CEO of the company, Tamela Peterson, along with their IT personnel, had a history of tampering with and or destroying evidence, specifically CCTV footage and records related to the investigation that the AG's office had previously been conducting, right?
That is correct.
There is nothing in any of your reporting supporting that information, correct?
It's in every affidavit that I wrote for every search warrant that I acquired.
Okay, but the information about that investigation, you personally have no personal information about any tampering or destroying evidence, right?
That was solely information another investigator provided me. That is it.
Verbally, right?
Yes.
Okay. There is nothing in your report that you investigated any of that, right?
Correct.
There is no report in evidence.com or in the Troy Police Department showing any investigation of that allegation, right?
Correct.
Okay. You have no personal information other than somebody whispered that in your ear from the AG's office, right?
Other than another law enforcement officer providing me that information, no.
Without any reports to back it up. Fair?
Sure.
Then, page 20, at the conclusion, this appears to have been written out ahead of time. Did you read this to the magistrate?
Correct.
Okay. Did anyone assist you in writing it?
No.
The above information only begins to paint the picture of the blatant neglect for safety protocols on behalf of the Oxford Center that ultimately resulted in the loss of Mr. Cooper's life and Mr. Cooper, right?
Yes.
Okay. And then you say, this investigation has shown a clear history of dishonesty, interference with investigations, predatory behavior towards vulnerable individuals desperately trying to get treatment.
Yes.
Okay. Where in your report is there any investigation of a vulnerable individual?
There are no less than 10 interviews with previous patients' parents documented in the case report, not by myself, but by other investigators that I dealt with that paint that picture very clearly.
At the Attorney General's office, right?
No. No, sir. We started to receive calls at the police department with people who wanted to cooperate and share information almost immediately after it occurred.
But nothing from the Attorney General's files about that prior investigation or in evidence.com, right?
No, those are interviews
No.
that we conducted, sir.
Okay. But nothing from the Attorney General's investigation that you got is in evidence.com. Is that fair?
Correct.
And Judge, for the record, I think at this point we've established that no other investigation from our office was involved in the evidence.com upload as it relates to this case. I think that question has been asked and answered a half dozen times.
I think I've heard the answer to the question at this point anyway.
Yeah.
Fair.
Judge, I have no further questions right now. Thank you.
Okay. Can we take a 5-minute recess and then pick back up with the next person that will question the witness? All right. You can take it also.
Thank you.
All right. He's present and important. I'm not going to make you put all the facts in the record. And you're still under oath. Please, thank you.
May I go?
Yes, I'm sorry.
No, that's okay. Good afternoon, Detective Trigger.
Hi.
How are you?
I'm good, thank you. How are you?
Good, good. Officer in charge of a case has a lot of duties and a lot of responsibilities. Is that fair to say?
Yeah.
You take an oath as a police officer, is that right?
Yes.
To protect those that are innocent. Is that right?
That is part of it, yes.
It's part of your oath. And you have a rule you're taught throughout your training, through all the way from going through as a cadet all the way up to a detective. You follow evidence. You don't come up with the conclusion and try to fit evidence into it. Fair?
Correct.
And you hold true to that, right?
Yes.
Okay. You heard two experts testify as we sat here, all of us sat here. You heard two experts testify in this case. Fair?
Correct.
As a matter of fact, I think my colleague, Mr. Gleason, even talked about you working with the experts in this case as they did their job, they did their homework. Is that right?
That is correct.
All right. And they made some opinions in this case. Is that fair?
They did.
All right. You have no reason, as we sit here, to disagree with those opinions, correct?
I don't.
Okay. And you also heard from Ms. Hosey,
Yes.
evidence tech. I'm sorry, I was thinking of law enforcement. She's a tech with regards to the chamber, yes?
She was a tech at Oxford at one point. That's my understanding, yes.
Okay. And you interviewed her at length, correct?
I did.
She came in here and testified, yes?
Yes.
You didn't disagree with her, did you?
No.
Okay. So, did you go out to the Brighton Center where my client worked? By chance? You ever go out there?
On one occasion that I can recall.
You remember the descriptions of offices where my client's office used to be?
I remember the description that was given to me by previous employees, yes.
Well, when you were out there, did you see they basically closed his office down and made it a billing center? You saw that, right?
I didn't go through all of the offices there when
Oh,
we were
I
out
see.
there. Yes.
Well, let's go back to our rule. Our rule is to follow evidence, right?
Yes, sir.
All right. So, you knew my client was retiring, correct?
I was not aware he was retiring. I think he referred to himself as on his way towards retirement.
Oh, I'm sorry. I don't want to get into what he said to you.
Yeah, I did not know what his employment status was outside of what he had told us during our conversation.
I want to get into the physical aspect of his office.
Absolutely.
Did you ever inspect it?
No.
Did you ever search it?
No.
Did you ever find it?
No.
Did you want to find it?
I had no reason to go find it. No, sir.
Do you want to investigate to see if you might find some clues?
In his office?
His office, you know, things we look for. Tablets, cell phones. I go into judge's chambers right now, I get a tablet. If I want to find something, right? You want to investigate, right?
We acquired those things outside of his office, so there was no need to go through his office.
You've never gone into an office, seen an extra one?
As not...
Cell phones, computers, things of that sort?
At the time, we were confident that we had received all of the items that were relevant.
All right. Did you have his cell phone downloaded
Our criminal investigations unit did conduct a forensic examination of his phone, yes.
And did you review that?
I did not go through that entire phone dump, no, sir.
Why not?
There was a procedure that was put in place that stopped us from reviewing electronic evidence related to this case.
There was a procedure put in place?
A taint team?
Oh,
Yes, sir.
is that for my client?
We were told to stop reviewing all electronic evidence for all clients until a resolution was come to as it relates to that specifically.
Thank you. May I approach to the your court reporter, Judge? Is something, Mark?
Yes.
Thank you. Text messages. Judge, may I approach?
Yes, you can.
I've already shown this to given a copy to the prosecution. Detective Trigger, I'm going to be handing you what has been marked as defense proposed Exhibit R. And have you look at this for a moment. These are text messages. And you can see the blue is from Tammy, the green's from Gary, or green is related to Gary. You see the blue and the green on Exhibit R?
I mean, I see
The text messages?
Yeah, I see the blue and green boxes. Yes, sir.
Okay. So up here on this Exhibit R here, there's a middle. This from Tammy's cell phone to Gary Marken. This is dated, I think this is 12/8/2021. You see that?
That's what it says.
What it says. Right. And then it has on here, there are, in Troy, this is an issue, Chamber 1. And it's Chamber 1, it gives serial number 33H008, has down on it 18,200. You see that?
I do.
Okay. Then the chamber in question, the middle one here, Chamber 2, 33H00377, as of 12/8/2021, has 15,094. You see that?
I do.
Okay. Now, Gary responds, what are you thinking? Goes to the next. And I'm going to get to here. Goes on, and there's a text about driveways and the like, but I want to get to the next portion of this text that you had your team do and dump, which is on page 602, I believe, or 601. Let me see here. Yeah, 601. Tammy writes out the one in question here, 33H0377, built in 2013.
Mm-hmm.
That's the one we have in question here, correct?
That is correct.
All right. And in 2022, she writes to Gary, there are 16,000, what does that say? I can't see it.
16,632.
16,632 cycles. Is that right?
That's what it says.
Okay.
And I'm sorry, Mr. Flood, what's the date on that last one?
This is 22. It's October 5th.
October 5th, thank you.
Do you remember when we walked through all these numbers of how big the numbers jumped? Remember I walked through the witness with that?
Yes, sir.
Did you ever find a year
for any chamber, because you investigated all the chambers to make sure that you weren't convicting an innocent person. You looked at them all. Did you ever find any chamber that had, I don't know, 3,000 cycles done in a 4-month period?
They didn't log the cycles for their chambers, so I really couldn't speak to that.
Did you ever look from that of Seacrest? When they did, you know how Seacrest, I know you say they didn't log, but Seacrest has these records. And you have the subpoena power. You have the search warrant power. You could go over to Seacrest and you say, hey, give me, because I'm going to tell the judge I'm not cheating, give me all the records to show this is not some aberration, some miscalculation. Did you ever do that?
We only did it for the chamber that was involved in the
I
crime
see.
we were investigating.
I see. Wasn't that odd? That you see 3,000 jumps? Isn't it odd that would happen in a 4-month period?
I don't believe so, no.
How many patients would you have to see?
If I was better at math, I'd have a different job, sir. I don't know.
Well, hey, listen, you got a man's life in your hands. I'm not, you can go.
I don't know.
You take an oath.
I understand.
And you take it seriously, right? You tell a judge you take it seriously. You want to just say, I'm not good at math, therefore I don't have to go to get help?
Judge, I'm
No,
sorry.
sir.
All right.
I'm going to object to the argumentative nature of that question, Judge.
Very well. All right.
All right.
So,
Is
I'll
that in
move on.
response to the objection?
I'll move on.
So I'm going to rule that the objection should be sustained. I'm not even really sure where to strike that last portion of what was happening, but
Well, let me rephrase it.
all right, that would be better. I think I'd appreciate it if you could do that.
This is a serious matter. You're here today, right?
Without question.
Right. And you want to make sure that you're doing things right, correct?
Absolutely.
So you didn't look at the text messages to see correspondence with regards to how many cycles were recorded on a particular day, correct?
I complied with a court order not to continue to review your client's phone.
My client didn't have a taint order.
So we were told to stop reviewing all electronic devices until the taint team had all of that figured out, and we turned all of that evidence over to them.
Detective, you gave me that text chain. That came from you.
Correct. We gave you the full extraction of your client's phone number. That is absolutely correct.
Okay. So, at some point in time, did you ever look to see if these numbers seem to be an aberration, seem to be out of line? Did you ever
Judge,
see that?
I'll object. That question's been asked and answered a few times now. She said no.
Oh, okay. I'm sorry. I thought there was an objection to that. She said no. Thank you. I'll move on then. I didn't hear her say no. Who is Mr. Gang? G-E-N-G.
It's my understanding that he is an employee at the Oxford Center, or was at the time the incident occurred.
Where?
He worked out of the Troy location primarily.
Was he the safety director there?
At the time of the incident, no, sir.
Was he on the website at the time of the incident of being a safety director?
I do not know the answer to that question.
Did you look at the website?
I don't recall seeing anything as it relates to him specifically off the top of my head at this point.
In your report, do you write something about him being a safety director?
It is certainly possible, but I do not recall off the top of my head.
So I'm going to hand you your report. Oh, it's the new one. I'm going to hand you the new one. Yeah, Crutcher.
Yes.
Here's your report that I'm handing you. Could you find where you write about Mr. Gang?
Judge, I'm going to object. Is he asking the witness to look through, 180 pages?
Well, I also am wondering, are you asking her to do this because she's indicated it's going to refresh her recollection?
Yes. She says she can't remember. I'm giving it to her to see if that helps her refresh her recollection where she wrote about Mr. Gang.
Is it in the report?
Yeah. It is in her report. She's the author.
Okay.
Am I missing something?
Is there a portion of this report that you're offering up to refresh her recollection? If so, can you please present it to her? I'm not going to have her go through 100 and some odd pages here without a little bit of direction. So if you could just point it out to her, that would be fine.
I'd have to tag it and go through it. Do you remember writing about Mr. Gang and how fast you would be able to find that in your own report that you authored?
Mr. Gang was referenced multiple times in here. I'm not trying to be difficult, sir. I do not know what you're referring to specifically off the top of my head.
Well, referring to your research and your information you did with him as it relates to his position
at the Oxford Center. Do you remember doing any of that?
Not off the top of my head, no, sir.
Would you have any reason to disagree that you wrote about him being in charge of safety out at the Troy Oxford Center?
With all due respect, I'd certainly want to verify that.
You'd want to
before
verify
confirming
it? Okay.
Yes.
One moment, Your Honor. Oh, yeah. Excuse me, I'm sorry. If you go to page 54, 115, the time of this incident, if you could read to yourself, and I'll point up to me. Approach, Your Honor.
Yes.
Thank you. This is page 54 of 115. If you look in here, read this sentence to yourself for me.
Yes, sir.
You see that?
I do.
Thank you. So you remember doing your work, doing your job, the person that's in charge out there at Troy at this time, gang, is listed as the lead hyperbaric technician for the Troy Tech location.
Correct.
Okay. Do you remember doing some research and figuring that out?
That was a result of reviewing records that we recovered pursuant to one of the search warrants, yes.
I see. As a matter of fact, you can tell the court that Mr. Gang, G-E-N-G, you watched the videos of this young boy that died, this young boy that passed. You watched those videos, is that right?
I watched the video of the treatment that resulted in his death.
Did you watch any others? The other 35 that you put on evidence? Did you ever watch those?
Those aren't on evidence.com. They were provided to you guys on a hard drive due to their size. But no, I did not review all of his prior treatments.
Do you remember writing in your report, Gang appears to have been one of the other technicians involved in the Cooper treatment?
That is, yeah. Yes, sir.
Okay.
Absolutely.
All right.
Based on the records that he signed with his name.
Oh, I see.
He initials next to the treatments.
So you saw that, and he was there, and he was actually one of the lead technicians out at this facility.
No, we saw that he was a technician that provided treatments to our victim based on the paperwork we recovered.
Okay. 1 second, Your Honor. I'd move, I think there's no objection, I'd move to admit Exhibit R into the record, Your Honor.
No objection, Judge.
You looked at the arson report in this case, yes?
The fire report,
Yes. Arson investigation report.
I have not reviewed the full arson investigation report in its entirety.
What did you review?
I thumbed through several pages. I have not read that in its entirety, sir.
I see. You would have no reason to disagree with it?
I can't speak to any of the content on it at this point without having thoroughly reviewed it.
Did you ever talk to the person that authored it?
I was told that he had completed it. As far as the content that is contained within it, we did not discuss that.
I see. Did you instruct anyone from your team to do a basic dump on my client's phone to see when the last time he may have been in Troy over the past decade?
Generally, location data is a portion of what is extracted from someone's phone, but no one was explicitly instructed to look for that.
Do you know, as you sit here today, do you know when the last time my client was in Troy?
I could absolutely not say with certainty.
Prior to January 2025.
Could not tell you.
Would it surprise you to know that he hadn't been there more than 3 years?
Judge, yeah, I'm going to object. The question is assuming facts, not in evidence.
I'm just asking if it would surprise her.
And then it's not relevant, but this detective surprises.
Well, I thought she took an oath, Judge. I'm sorry, maybe I misheard it, to protect the innocent. And it would be relevant information if she would have figured out that my client hadn't been there in 3 years.
Which is, again, also, Mr. Flood is now testifying to where his witness or where his client was. There's no evidence that proves that.
All right, let me ask you it this way. I'll rephrase. Would you want to know, as you would be someone that stands up and puts your hand above that flag, would you want to know as an officer in charge that my client hadn't been there in 3 years? Would that be relevant to you? You being the officer in charge, would you want to know? You're a cop. You're a detective. Would you want to know?
If that was pertinent to what we were investigating.
Okay. Thank you. Thank you. I have no other questions.
Your Honor, I have some cross prepared, but frankly, I'm not comfortable going forward without having a chance to review the additional reports. Part of my concern, and I was talking to Mr. Kessel during the break, and again, I don't doubt what Detective Trigger is saying, but essentially when she was listing what she thinks that we're missing, like one thing that all of us we know are missing is this white side chart, is that table, whatever, that he I don't have it, no one else seems to have it, but it's not listed as something that Detective Trigger thinks that we're missing, and so I'm not comfortable.
Seen a chart.
Well, he testified to it. You heard him testify, correct? That he produced a table, a breakdown of the things related to, I believe it was Mr. Mosteller's phone. Because I know as soon as he said it, and I think even the judge noticed that all of us were looking at each other like, what is he talking about? None of us have ever seen this. So while I can appreciate what Detective Trigger is representing today, that we haven't really missed anything of consequence, I'm just not comfortable saying that I can start my cross and know that I'm going to ask everything that I want to ask. And I would prefer to just do it all at once I've had a chance to review all the documents, and then go back perhaps to Mr. Kessel or to Detective Trigger, because she's always been very responsive, and discuss with them if I think there's something I'm missing given all the testimony that we've already taken. I'm not confident, but I'll leave it to the court to tell me what to do.
Just so I can be clear on what she testified to previously, she indicated that she did not add any additional reports or documents documents from the investigation after what was contained in the initial report. Was that correct?
With the exception of
With the exception
the
of-
items that I had listed. That is correct.
Okay, can I just ask a question of the witness?
Of course.
Okay. One of the things that you listed, I think you referred to them as narrative supplements or narrative reports.
Correct.
What phrase did you use?
It was probably something to the effect of, separate narratives or supplemental narratives.
Okay, yes, I think that was it. So is what you're saying is that all of the supplemental narratives, and I'm just trying to be loud because I know I'm a little bit far from the microphone, that the supplemental narratives are only having to do with alleged bond violations and taint team discussions, or there are other supplemental narratives of which you can't tell us necessarily what they're about?
So, all of the narratives that I'm familiar with that came into existence following what you guys were initially provided
Yeah.
relates to bond violations, follow-up related to those bond violations, or review of electronic devices pursuant to the taint team procedures,
So there is review of electronic.
which were emailed separately.
Okay.
They were provided to prosecution and emailed to you guys as separate narratives at the same time as the autopsy report and the MSP fire report.
I did not get that.
That's the thing I'm missing. And Judge, if it adds any help here, we gotta come back anyway.
Well, I'm about to talk to you about that too, and it's going to be probably sooner rather than later. But the other issue that I thought, perhaps, if there were questions that you could ask that you were prepared to ask, if then when we return, you had an opportunity to review anything that you received today. This is an officer in charge, so they're going to be here, so I, of course,
Sure.
would allow you to ask to have her recalled. If there's something else that you are going to find when you review the documents that were sent over today that you didn't have originally, I would have no objection to that.
Okay.
I just don't want to not take advantage of the time that we have.
Sure.
So if you were prepared to begin, and I'm not sure if the same issue is going to be raised by your colleague, perhaps. I wasn't sure. She seemed to be standing up at about the same time. So, if either one of you would at least be prepared to begin questioning her about whatever you had intended on questioning her on, yes, we are likely going to have to come back. And I would give you an opportunity, even if you've already asked her questions on cross-examination, to have her recalled or to continue cross-examination and ask questions about any documents that you determine were given to you today that were not included in the original packet. But
I'm joining with what Attorney Shalom is saying. I did have a chance to peruse the chart, or whatever word was used to describe the document that was created.
What's up?
Yes. Chart? What do you
I
call
can
it?
see it.
Table.
The table. And my client is very much a part of that document, so it is especially important that I have a chance to review that. And I don't know how that will affect any other approach I'll be taking, because it's a pretty important document for my purposes.
are you talking about the document that Detective Whiteside testified to?
That he testified that he created, and as the officer in charge, I may have questions to her about that as well. It gives a larger perspective of the investigation, because it addresses the 35 prior dives, which I also didn't receive until last week, even the video of those dives. So it's getting now a documentation of these dives and their law enforcement perspective on these dives and their chart around it.
I don't know that this would be the appropriate witness anyway, that you.
She's the officer in charge, so there's always, things to address with an officer in charge who covers the whole investigation. I don't know what's there. I just don't know, but as the officer in charge, she certainly has her hands in every piece of this puzzle here.
Okay. Well, if it's determined that there would be something that she needs to be questioned on based on what you've received today, you'll have an opportunity to do that. But as far as whatever you were planning on questioning her about today for cross-exam, I'd like to keep going. So I don't know who would like to go next.
Good afternoon, Detective Trigger. Who did that belong to?
I don't know.
Oh, that's Mr. Gleason's.
Can I approach and just?
I stole it.
Please. And, would you like to
Appreciate
have defendants are published to the court at this
Yes,
time?
please.
Thank you.
I have, or I think it's Robertson report. Sorry, Your Honor. Okay. Hi, Detective Trigger.
Hello.
How are you doing?
Good, thank you. How are you?
I'm okay. So I know there's been some discussion about the records from Seacrest as it relates to chamber number 2.
Yes.
Okay. Have you done any research as to, well, let me ask you this. When did the Oxford Center open?
I have no idea.
Okay. You don't know when the business came into existence?
No, ma'am.
Okay. What about specifically the Troy location?
I do not know.
Okay. Do you have any idea on average the number of dives the business would complete in a month?
I do not.
Okay. Did that not seem important to you to try and figure that out?
As it relates to the death of Thomas Cooper, no, ma'am.
Okay. Is it your understanding that the wrist straps have never been used by the Oxford Center?
No.
That's not your understanding?
Correct.
Okay. Can you explain that?
There was an interview that was conducted with 2 of the defendants where there was indication made that at one point they were there.
Hold on a moment. I'm sorry. Just 1 minute.
Absolutely.
Could you say that again?
Your Honor, I recognize that there are 4 defendants here, but the statements of defendants are only admissible as to that individual defendant. So to the extent it's not Ms. Peterson, it would be hearsay and I would object.
Okay.
I would object as to any statement unless you're going to enter the whole 3-hour statement as it relates to my client. But we already talked about this in chambers and put it on the record last time we were here.
Yes, so you're just noting your objection and then the court will,
Yes, Your Honor.
okay, act accordingly. Thank you.
Okay. So can she continue?
Yes, please.
Okay.
I don't know if it's important then to state which defendants.
Yes, I was gonna.
Thank you.
Okay. So you indicated that you had information that wrist straps at some point were used by the Oxford Center.
That is what was reported to me during interviews of defendants, yes.
Okay. Which defendants?
Mr. Marken specifically had indicated that.
Judge, I'd ask under rule of completeness. I mean, first of all, it's my client. I'll just give you my whole 3-hour interview. We have it transcribed and recorded by an official transcript. That's what we want to have done. But I object to having any comments as it relates to my client and the statements coming in and this witness at this time.
Did you want to respond? I don't know if you need to respond, if he
I
needs to
think maybe Ms. Sharon should respond first, and then I'll.
I mean, I'm familiar with the rule of completeness, but I don't think that requires that the 3-hour interview be admitted if I'm just asking the source of information that she has of wrist straps initially being used.
I would agree with that, actually, Judge.
Well, we don't have a time, a place, when it was said, when he's thinking. I mean, he
I haven't asked any more questions because you've objected.
yeah, I know, but I don't want to go down that slippery road, and I'm sure you can understand that.
Well, if you're offering to have the entire transcript that's
I
3
think-
hours in length being admitted as a
Exhibit. Sure.
piece of evidence in this case, then I don't know what slippery slope would be.
Because it would be
talking about.
taken out of context if I said something that you said, or someone said, Your Honor, and it didn't have the content of the date, the time, and the reference or the referral to it. Now-
Can we just pause for a moment, and I'm going to reserve making a ruling on your objection to let her ask some additional questions to
Okay.
determine if that can be established.
Thank you.
Go ahead.
Okay, so it's your testimony that Mr. Marken indicated to you that at some point wrist straps were used.
Correct.
Okay, the grounding wrist straps.
Correct.
And is that at Brighton or at Troy or at both?
I don't recall him indicating a specific location.
Okay. Do you recall him indicating a specific time frame?
He did not know off the top of his head when exactly the transition took place.
Okay. Do you know when Mr. Mosteller started his employment with the Oxford Center?
Off the top of my head, I want to say it was 2019, 2016, somewhere in there, but I don't remember for sure.
Okay. Is it your understanding that the wrist straps were being used at the time that Mr. Mosteller came to work at the Oxford Center?
Based on his interview, they were not.
Okay. So when he comes to work at the Oxford Center, they've already stopped using the wrist straps.
That is the information that he provided to me, yes.
Okay. So would you agree then that the natural inference from that is that Mr. Mosteller did not have input into terminating the use of wrist straps because it had already started?
Yeah, Judge, I'm sorry, at this point I'm going to object. First of all, I think it calls for speculation. And second of all, now she's introducing her own client's statement, which I think is hearsay.
Statement against interest.
How is it a statement against interest? If he's saying the straps stopped being used before I was there, that's not a statement against interest.
Fair enough.
Like,
Okay, so I'm going to sustain on the basis of hearsay.
Okay. So okay, you interviewed Mr. Mosteller, correct?
I did.
Okay. And you questioned him about not using the wrist straps, correct?
Correct.
Okay. And you challenged him quite strongly during that interview, is that correct?
Yeah, you could say that.
Okay. The deeper you get into the interview, would you agree that your tone became slightly more aggressive and confrontational? And that's not a criticism, it's just an
Without question, yes,
Okay.
that is accurate.
And you challenged him, given his experience, about why he agreed to not use the wrist straps, correct?
Yes.
Okay. And on multiple occasions during that interview, he explained to you...
again, Judge, I'll object to hearsay.
I don't think it's for the truth of the matter asserted. I think it's an explanation of why he acted the way that he acted. I mean, that's kind of the way prosecutors get these statements in all the time. It's just an explanation of his understanding of why he acted the way he acted. I don't think it's for hearsay purposes, Your Honor. And actually, if he's explaining to Detective Trigger why he wasn't engaging in the use of a wrist strap, that is a statement against interest. Because it's an admission that he's not using the wrist strap, and it's an explanation for it, so that is a statement against interest.
I think we have two things going on here, Judge. Him stating his belief is sort of the truth of the matter asserted. I think that's issue number one. I mean, I don't know that the defense would say that this is a statement against interest because her entire argument this whole time when questioning witnesses has been that you didn't need the grounding straps. So if the grounding straps weren't necessary, I don't know why him saying they weren't using them is a statement against interest based upon counsel's questioning and argument.
Certainly, Your Honor, in the prosecution's case, it's a statement against interest. I mean, are you really going to argue that it's not a statement against interest in the way that you're presenting this case?
But I'm not the one offering the statement.
That doesn't change whether or not it's a statement against interest. The status of something being a statement against interest is whether or not it is, in fact, potentially against his penal interest, which in this case it is due to the prosecution's theory of the case.
Yeah, Judge, the problem is the problem is that what his explanation is part of, I'm trying to think of how to say this eloquently. What he's saying, what he's basing his belief on is the truth of the matter asserted. So if he's saying this wasn't necessary because that's the truth of the matter asserted. If he admits to not using them, I suppose that would, based on our process, would be a statement against interest. But I think the why is when you start getting into the truth of the matter asserted, if that makes sense, that distinction.
It can be for the truth of the matter asserted and at the same time be a statement against interest. And if it's a statement against interest, then it is admissible.
And I guess, Judge, the why is not a statement against interest. That he was not doing it, I think I understand the argument that it's a statement against interest, but if he's going to explain why he was believing that goes to the truth of the matter asserted, that he wants the detective to believe the reason he was acting a certain way is the truth of what he's saying. If I'm making myself clear.
Your Honor, when this case was originally charged and throughout, right, the entire theory is that my client is somehow culpable of second-degree murder because he conducted experiments or tests or had certain knowledge that made him think that the wrist strap wasn't necessary. So his explanation related to any of that, right, that confirms that he didn't use a wrist strap is a statement against interest in their eyes. I don't understand. I think it's such a disingenuous argument, with all due respect, to say that his explanation of why the wrist straps weren't being used isn't a statement against interest, when that's the entire theory of their case. It's not just that the straps weren't being used. It's the knowledge that he had that should have allegedly led him to know better. And so if he's explaining to the detective why he took a certain action, of which now he is charged second-degree murder, it is a statement against interest.
Judge, I think the distinction is that there's a separation between whether he was using the strap or not and the why. Whether if it comes in that he says he wasn't using the strap, I certainly agree that is a statement against interest. The why is the problem we have, and the people's argument is not that he wasn't using them because he thought it was safe. The people's argument, quite frankly, is he knew full well that he should be using them. So this why is not something that falls in line that we think is accurate or is part of our case. So the why is that he wants this detective to believe what it is he's saying as to why he was acting a certain way. This is being offered for the truth of the matter. Why didn't you do it? Because I did these things, and Ms. Sharon wants this court to believe that what he's saying is true.
Okay. So you're representing that these statements, and I believe you were attempting to actually place the statements onto the record in the form of your question, to then ask if these were statements that were made to this detective during the interview.
Yes.
So I didn't hear it as though you were asking her what was said in the interview, and she was reporting back to you what was said in the interview, and that's what you objected to. You were actually attempting to place what you believe as your client's statement into the record in the form of your question.
Yeah, because I'm on cross-examination.
Right.
Yeah.
But from what I'm hearing, it appears that the hearsay exception could apply based on the argument that's being made, that's being represented to the court from Ms. Sharon.
Okay.
I'm going to allow her to ask the question.
I'm sorry, you will allow me to ask the
Yeah.
question? Okay. When you asked Mr. Mosteller why he wasn't using the strap, okay, am I correct that on multiple occasions during that interview he indicated to you that he firmly believed that the chamber was grounded and so that therefore the patient was grounded?
It was a portion of an explanation that was provided.
Fair enough. Would you agree that another portion of the explanation was that he had read an article that told him how highly unlikely it was that a fire would start in a chamber from a single spark?
And I guess, Judge, before that question is answered, this now is Mr. Mosteller's statement asking us to believe that he read this article. That would literally be the statement is coming in for the truth of the matter asserted. So I would object to that question and a potential answer.
Your Honor, I think any explanation that he gives as to why he didn't engage in the use of a wrist strap is a statement against interest, because that's exactly what he's charged with here, right? That has always been part of the narrative of the prosecution's case, is that he ran experiments that he thinks proves that it was safe. So that's all part of the theory of their case. To argue otherwise, I mean, it's all over the discovery. The video with the experiments, photographs with the experiments, and that this is what made him think that it was okay to not use the wrist straps. And so it is a statement against interest because they're using that as part of their case to indicate that he was not careful, that he didn't comply with the training that he had. I really don't understand how it's not a statement against interest.
Judge, Mr. Mosteller's statement is him excusing the non-use of the straps. That is not a statement against interest. That is a statement, a self-exculpating statement. When he is questioned by Detective Trigger, why weren't you using these straps? This is his explanation as to why he wasn't using them. Therefore, I wasn't using them because I thought it was okay. That's not a statement against interest. That is a statement in his own defense.
Yeah, I rest on that. I mean, I'm not going to waste the court's time by repeating the same argument over and over again.
I'm assuming you wanted to take a look at something before I ruled. I wasn't sure what you, did you want to check something?
May I, Your Honor?
Yes, of course.
Okay.
Sorry, Judge.
Your Honor, I think the reason why it doesn't fall into hearsay is because it's Mr. Moss. I'm sorry, were you in the middle of something? I was looking down.
No, that's fine.
Okay, I apologize. That it's to explain his state of mind and not for the truth of the matter asserted. You know, she's inquiring him and challenging him as to why he didn't engage in this safety action, right? And that's just him explaining his state of mind, not for the truth of the matter asserted.
Does your position change based on the change in the exception that she's seeking?
At that point, Judge, I'll leave it in the court's discretion.
All right. That seems much more reasonable than the argument that you're making about statement against interest. So I'll agree to allow you to ask the question that was previously objected to.
Okay.
So I'm sorry, it's coming, just want to clear, it's coming in under the defendant's state of mind at the time that he's being interviewed by this investigator. That's what the ruling is.
That's what her argument is, that she's seeking to have this statement that he made.
Okay, even though the behavior happened some 4 or 5 years before that, right? That's what.
But this is Ms. Hageman's Clark's witness, Your Honor.
That's okay. Well,
I'm just trying to get clarification.
Sure.
Your Honor, I think what Ms. Hagman-Clark is trying to pinpoint is the hearsay exception. What I'm arguing is that it's not hearsay at all, because I'm just asking for his state of mind, not for the truth of the matter asserted.
I think the distinction, Judge, is his state of mind when he's being interviewed by Detective Trigger versus his state of mind over the last several years. I think
As
that's.
long as it's not coming in for the truth of the matter asserted.
Yeah, I mean, we're all, I think, understanding it's not coming in for the truth of the matter asserted. I'm just saying there's the distinction of his state of mind when he's being pressed by Detective Trigger versus what he had been doing the years prior. I think that was the.
well, I think that's something that maybe Ms. Sharon could clarify.
Sure.
That's an important point.
If it's just for his state of mind as opposed to for the truth of the matter asserted?
No, I don't think that there was a distinction. I thought everyone was on the same page at that point, that it's not for the truth of the matter asserted.
Right, that's why it's not hearsay. It's to testify as to his state of mind.
Are the people asking for further clarification on state of mind?
I'm not asking for further clarification on that now, but I guess my response is, how then is it relevant? If it is for his state of mind, then it doesn't go for the truth of the matter asserted, then who cares what he said to her?
Well, I think his state of mind is relevant as to his intent, which the prosecution has to prove.
Great, but I don't believe that she can admit his statements that he gives that are being part of an interrogation. She's not allowed to admit those. She's not an opposing party, And even if it's being offered as a state of mind, then it doesn't go for the truth of the matter asserted. So then my question is, how is it relevant?
Why he did and why he did it.
Yeah, I mean, the case is all about why he didn't do what he didn't do, why he did do what he did do, and what led him to making certain decisions that have now led him to be charged with second-degree murder.
But
So
that would be for the truth of the matter asserted. Why he did what he did is for the truth of the matter asserted.
That's not true.
That's not
We do
true.
it with police officers
All the time.
I mean, police officers, you ask questions. Did you get a phone call? Yeah. What did happen? Johnny told me he was getting robbed. Boom, I go to the scene. Why did I do X? I went there. That was my state of mind. This goes to the declarant's state of mind. What he did and why he did it.
that is exactly how prosecutors always use it. It's not for it's just to explain why I did what I did, which is exactly what I'm trying to do here. Okay.
Chief, for the opportunity just to look at a couple of things. Obviously, I'm consulting the rule of evidence that you are seeking to have this statement admitted under as a hearsay exception. And then obviously taking into consideration the objection from the people as to whether or not it could be possible that the statement that you're seeking to have introduced is not for the truth of the matter asserted. I understand that there's some back and forth here about how a prosecutor would potentially use the same evidence to introduce and use the exception as state of mind. I think it is perhaps the way in which the questions are being posed to the witness in determining whether or not this exception could apply. Clearly, one of the elements of second-degree murder is establishing a state of mind, one of three, that the court would have to determine for purposes of the preliminary exam that the people have presented evidence to satisfy to a probable cause standard, that the defendant had one of three states of mind that are required to find the case over. In asking the questions of the witness, statements that were made during the course of the interview, I'm not certain that I can even ascertain that the statements would establish a state of mind from any stated period in time. I don't think that it's very clear, based on the questions that are being asked at this point, that I could determine that this falls under the hearsay exception that you're seeking to introduce it.
I missed the last sentence.
I'm not sure that I have enough information at this point even to determine that it could fall under the hearsay exception that you're seeking to have it admitted under.
Okay.
So at this point, I am going to sustain the objection for those reasons.
Okay, Rana. You talked about going about the Oxford Center in Troy and looking in drawers and searching things and finding a container that you believe had wrist straps, correct?
Correct.
Okay. So you're understanding that the wrist straps come with the purchase of a chamber?
That is, if I'm not mistaken, what the manufacturer had told us, yes.
Okay. So we can agree that there's no increase in cost in terms of having to purchase a wrist strap, correct?
Purchasing replacement wrist straps, I would assume, comes with a cost, but at the time the chamber is purchased, the manufacturer told us they provide a wrist strap with it.
Do you have any knowledge that wrist straps over time have to be replaced?
I do not know.
Okay, so that's just an assumption that you're making?
I guess if a cost was associated with it, I am assuming that is where that cost would come from. Yes, correct.
Do you know what it costs to replace a wrist strap?
I do not.
Okay. Do you know if it's an expensive undertaking like buying a chamber?
I don't know.
Okay. So the wrist strap comes free, right? Well, it's included in the purchase of the chamber, right?
That is what I recall being told.
Okay. And certainly the allegations here are that the safety of Thomas Cooper was ignored by not using the wrist strap, correct?
It's one of the things, yes.
Okay. What is the benefit to the Oxford Center of, I mean, you would agree with me that they don't incur any financial benefit by not using the wrist strap, right?
But not-
Judge, I'll object. It calls for speculation.
What? She's just testified that the wrist strap comes with the chamber, right? So she certainly can testify whether or not she's aware of any great savings to the Oxford Center by not using the wrist strap.
But she can't, Judge. I understand the question, and I'm sorry, I thought you were asking about replacement wrist straps, but she's asking a detective to talk about the internal financial workings of a business that she obviously has already said she doesn't know when it started, so she's asking her to speculate.
No, it's not speculation because she can testify to the fact, as she just had, that the wrist strap comes with the chamber, Your Honor. Your Honor, all human beings know that when safety corners are cut, as is alleged here, okay, which I certainly don't concede, but that there's usually a benefit to the business for doing it, right? It's usually motivated by greed, and I'm simply trying to establish through this witness who knows about the wrist strap and how it's gotten by the business that it's not an expense that the business incurs, right? So it's not as if the business isn't engaging in this practice because it's trying to cut corners for a financial gain. And I think that that's important here because we have to get to the motive of why allegedly these criminal actions happened, right? I think ultimately the evidence is that there is no motive, but I think that's important for the court to understand.
And Judge, I don't necessarily disagree with Ms. Sharon's statement, but she's asking this witness, bless you, she's asking this witness to speculate as to the financial ramifications of the use of a piece of technology that she did not know about before this case started. That's my issue. I understand the argument, and I'm sure the argument's going to be made, but this witness is not in a position to answer that question.
Your Honor, she's been investigating this case for 9 months. She's educated. Like, I agree, right? When I first got this case, I kept saying bariatric instead of hyperbaric. This isn't something that your average person is familiar with, but this detective has been working this case for 9 months.
I think it's fair to ask her if she knows. If during the course of her investigation she came to know of any reason that she would do this. If she has an answer, she can answer it. I don't want her to speculate, though.
Okay, so you know that the wrist strap is included with the chamber, correct?
That is what I recall being told, yes.
Okay. Have you ever uncovered any associated cost with using this strap?
With using it or not using it?
Using it. In other words, have you discovered that in any way that the Oxford Center is saving money by not using the wrist strap?
Could certainly provide a theory based on what we've come across, but
Well, the judge
I'm not
doesn't-
comfortable doing that. So
Okay, so you haven't developed anything then?
we have no. I mean,
Judge, I'm sorry, and I'm sorry, but she said she has a theory that we have discussed, but so she does have a theory, and she's just not going to speculate on the answer. And I think Ms. Sharon's question was, so you don't have a theory, and she's saying we do.
I'll withdraw the question, Your Honor. You agree that chamber number 2, that you've seen documentation that alleges by November or December of 2024, it was over 20,000 dives.
I believe it was 2024. I can't recall off the top of my head. I know it was December of a certain year. They indicated that it was over 20,000 dives. I'd have to see the email to say for certain.
Okay. I'm sorry, I misspoke. The maintenance record was from December of 2022.
2022.
Thank you. Yesterday, when we were reviewing the documents with MASH, right?
Yes.
We reviewed a document from December of 2022 in which Seacrest indicated it would no longer service chamber number 2, correct? Because it was over 20,000 dives.
That is correct. Yes.
Okay. So in December of 2022, it allegedly was over 20,000 dives, correct?
Yes.
Okay. And you heard testimony that chamber was purchased in 2013?
Yes.
Okay. So, and Mr. Mash, not Mr. Mash, Mash testified that typically when a chamber is delivered, it'll have between 4 and 6 clicks on it typically.
I do recall him saying that. Yes.
Okay. So in the span of 9 years, my math is horrible, 9 years, that chamber accrued allegedly over 20,000 dives, correct?
Based on the evidence we discovered, yes, that is accurate.
How many times have you been called to the Oxford Center for a fire?
This is it.
Okay.
This is the only time.
And this wasn't the only chamber there, correct?
Correct.
Okay, they had 2 other chambers, correct?
Yes.
Okay. Do you have any idea how many dives each one of those chambers has done in its lifetime?
I do not know off the top of my head, no.
Okay. Do you think it's not, I'll withdraw that question. Your Honor, at this point, I would say that I'm not prepared to continue. I'd like a chance to take a look at the new documents.
Okay.